Morning again. John Banner with Banner & Banner Law Firm. Today I want to go over one of the things I do the most around here, which is drafting and sending out writs of garnishment. Writs of garnishment is a pretty standard process for collecting on judgments. Once you have the judgment, you need to have some way to collect on it. And writ of garnishments are the primary tool that I think applies for most people most of the time. Writ of garnishments can either be sent to an employer or also to a bank. Usually the ones that go to an employer take a little bit longer and it's an ongoing process. The ones to the bank, well, it only takes the money that's in that bank at that time. So of course it's a much quicker process, but nevertheless if it doesn't find all the money and it finds some money, it probably finds all the money that that particular debtor has available at the time. So it doesn't make sense to just keep redoing more bank garnishments for them. There are some circumstances to where writs of garnishment can be sent to other places, but it's very common that it's limited to either employers of a debtor or the bank of a debtor. And so what I have here is our standard printout for a bank garnishment. Bank garnishment starts, it's about 50 or so pages worth of documents at the start of the process. A employment garnishment is about 80 pages. So when I say there's a little bit of paperwork that has to get shuffled around, that's what I'm talking about. So going through the writ of garnishment, they start off pretty well the same for bank and employers. You draft the application for a writ of garnishment and a proposed writ of garnishment, and you get that signed off on by the court clerk. The court clerk takes a small fee, $12 to $20, and once you have your writs, then you can send them off to the garnishee, meaning the bank or the employer. The bank or the employer will receive it and needs to start following what the writ says, because it is a command from the court, as soon as they get it. So banks are pretty good at this. They've got procedures set up. Whenever they get it, the first thing they do is they put a hold on the account. They will notify their customer, the debtor, of that hold, and they usually take a processing fee themselves. Also, there are some they're called exemptions. They are the amount of money that must be left in the bank account. And some of them are automatic. That's a new law from about 2021. For most debts, that's $500, but the automatic part of it is $250. And that gives the debtor a chance to say that they want to use the whole exemption. A lot of debtors don't bother. For whatever reason, I think it works out better for them to try and get the debt paid off quicker, though they might nevertheless need the money. For a employment, there also is a certain amount of money that can't be garnished. Generally speaking, that means that the debtor gets to keep 75% of their wages. I say generally speaking because it varies based on the type of debt. But once the employer or the bank gets it and they start garnishing accordingly, they also have to fill out an answer to tell everyone, the court, the debtor, and the creditor, how much money is getting withheld. And they send out an answer form that the creditor's attorney provides, and it gets sent to each of the people that need to get a copy of it. And when you get a copy of it, you can contest it. Anyone can, the creditor or the debtor. It's pretty rare that anyone does contest the answer because it's a pretty standard calculation. And outside of the numbers not being accurate, there's no grounds to dispute what that garnishee is saying. But after that first answer, you get 20 days to contest it. You usually just give 30 days, and if anyone wants to raise an issue, we usually just take it up with the court if we can't resolve it. Sometimes garnishees have to get reminded, especially employers, about what they're supposed to do. That's pretty common. It's pretty normal for creditors' attorneys to have to talk with employers quite frequently. Once we find out how much money is getting held for a bank, then it's off to the court. But for an employer, you then have to wait a little bit longer to go to the court. Specifically, you have to wait about 60 days because there's two answers. It's continuing lien on wages as they're incurred for a 60-day period. After that 60-day period has ended, you get another answer from the garnishee that both sides get a chance to contest again. And if there's no contest that's happened based on that answer, then the judgment creditor has to take it to the court and demonstrate that they did everything they were supposed to do. that they provided the required notices, that the debtor has had every opportunity to contest the answers, and has apparently chosen not to or has not contacted the creditor's attorney. Once that has all happened, the court will issue something called a judgment on answer of garnishee, and that will direct the garnishee to pay the money that they've withheld either to the court or to the judgment creditor's attorney's office. And that'll be the end of that garnishment. For employment garnishments, unless that satisfies the judgment, which it usually doesn't, you just keep going. So one of the questions that comes up is, what about attorney fees? And attorney fees get added on, as do the cost on the garnishment, but not all the attorney fees. It's capped at $300. It's been that way for a while. And so it adds to it, but not enough. As always, if you need help with anything like this, please contact me, and I look forward to making future videos.